So I would say, again, this applies mostly to newer or less experienced lawyers. Where an older, treacherous lawyer like Miles can be successful is they can trip you up on foundational questions by making foundational objections. So let's say I'm trying to offer a document. And I think I've authenticated the document. I think I've created enough of a context to show that this email was sent by Mrs. Brown to Mr. Brown. And the senior attorney on the other side keeps objecting to foundation. And the judge just rubber stamps the objection, sustained, 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 and you're perplexed. And you can't figure out where am I lacking on my foundation in authenticating this particular document. Now, a typical, and I see it at the Trial Institute every year, a typical newer lawyer thing is to panic, deer in the headlights, and you say the magic new lawyer mantra of, fine, I'll move on, okay? First of all, you never want to say, fine, I'll move on. You keep plugging until you get it into evidence. Miles and I were taught by a man by the name of Steve Kolodny at the Trial Institute. And Kolodny used to have this saying, which is, you're like a Sherman tank and you're trying to break through the enemy wall when you're getting something into evidence. If you hit the wall and you're stopped, you back your tank up and you hit it again, and you keep hitting that wall until it crumbles. So with regard to this example that I'm telling you about, a little trick that, and this is from an evidentiary point of view, totally proper to do this, and I've done this myself. What you would say is, the other side keeps objecting, the judge keeps sustaining. So you would say politely and respectfully to the judge, Your Honor, with all respect, I think I have laid the proper foundation to authenticate this particular exhibit. Would you please instruct my opponent, Mr. Anderson, to advise the court where my foundation is lacking? Now, what you could do out of exasperation is to say, Judge, I think I've laid the foundation for this document. I don't know where it's lacking. Tell me where it's lacking. When you do that, you put the judge on the spot who may not, him or herself, even know why it's lacking, and may have just, as a matter of just kind of rote routine, affirmed and sustained the other guy's objections. When you make the other guy disclose it, he may not have a good reason for why it doesn't come in, and he may mumble something, in which case, hopefully at that point, the judge would let it come in. Does that make sense? So that's a tip that I would give to everybody. You may have the other attorney jumping up and down, I don't need to tutor this lawyer on how to try this case and blah, blah, blah. You know, the point of laying a foundation, whether it be authenticating a document or laying a foundation for testimony, maybe a conversation, is not that it's to be used as a club or a weapon to keep stuff out. It is just to give the judge enough information to know that the judge can reasonably rely on the authenticity of the particular document or the recollection of the witness who is testifying to a particular conversation. That's all. There's no magic to it. So if a judge is doing his or her job properly, they would readily say, well, if there's a problem with the foundation, counsel, tell us what the problem is so it can be remedied by the lawyer trying to offer that testimony. So that's the first thing I guess I would say is use that. Now, the second thing, and it's also with regard to foundation, is this. Under the federal rules and Illinois state rules and maybe Tennessee rules, I hope, I think it's rule 103 that talks about foundational testimony, okay? Again, foundational testimony is really designed just to make sure that the substantive good stuff that's coming down the road is reliable. So what this rule of evidence says is that when offering foundational testimony, the rules of evidence don't apply. Aha, what does that mean? Well, when I'm laying a foundation, I can have that witness rely on hearsay. I can lead that witness, okay? Here's a good example. When a witness forgets something and you're going through the refreshing memory dance, is your memory exhausted? Yes, it is. Is there something that would refresh your memory? They blank out. They can't think of anything. You legitimately could say, hey, if I showed you your pay stub from last week, would it help refresh your memory as to what your current income is? Oh, yes, that would be helpful. Thank you. I just leaded that witness. That was a leading question. But again, because that's in the nature of foundational testimony, the rules of evidence don't apply. So that's a second, I guess, tip, for lack of a better word, that I would recommend that people consider that. And then I think the third thing that I would recommend is figure out all of your evidentiary obstacles in advance of the trial so that you're not doing that dance in the middle of the trial, because you've got too many moving plates, you know, like that guy that used to be on Ed Sullivan, who you guys are all too young to remember, except for Miles and I. Yeah, we remember this guy. So you might have even seen it. There was this guy who used to do this thing where he'd spin plates on these poles, and he'd have like 20 plates, and he'd have to run to all the plates that were slowing down or they'd fall off. Well, as trial lawyers, we've got all these spinning plates. We've got our client jabbering at us. We've got to listen to the other side's questions. We've got to think about our own questions. We've got to play with our exhibits and all that kind of stuff. All these spinning plates. The fewer plates that you have to attend to, the easier your job is. So anything that you can adjudicate from an evidentiary standpoint before the trial starts, the better. Stipulations, if you can get them. Request to admit the genuineness of documents. Request to admit the genuineness of facts. Stipulation conferences with the judge. By the way, request to admit the genuineness of documents, right? We know that procedure, right? You have that, of course, in Tennessee. Yes?
Yes, but it's not often used.
What's that?
It's not often used.
It's not often used. Why do we use that? Okay, that's a rhetorical question. We use that procedure because it's laying our foundation for us. Request to admit the genuineness of documents. Remember earlier I said we've got 3 prongs to get something admitted. We got to prove it's relevant. Well, hopefully we're smart enough to know what's relevant and not relevant. We've got to show if it's a document that it's authentic. And then we've got to deal with any hearsay objections we might have to contend with, okay? The second prong is satisfied by the request to admit the genuineness of documents. You don't need to go through that authenticity dance if the other side has admitted that it's genuine or otherwise never answered within, in Illinois, it's 28 days. I presume it's something similar. One other thing to keep in mind too, when we talk about authenticating documents, if the other side in response to a discovery request gives you documents, aren't those legitimate documents, right? They wouldn't give you a forgery. They wouldn't give you an inauthentic document. That is a pure admission if they give you a document that it's authentic. They cannot, if you get the document from them at trial, make you go through that proof that something's authentic if they gave it to you. So another takeaway that I think is important for everybody to remember is make sure you have precise records of what you got from the other side with your bait stamp so that you can prove, or your paralegal can prove that's helping you out. We received this document from the petitioner's office on February 14th, 2021, exhibit number 4, base stamp 4A through 4G, whatever the numerology is. And then you still have to deal with hearsay, maybe relevance, but you don't have to go through that authentication dance.